do not put the necessary mechanisms for fair competition and an equal playing field for the women, then it becomes that much more difficult for women to compete. You can see the mess that has characterized the nomination exercise, the violence, the confusion, the high fees, the lack of proper financing mechanisms, to manage campaigns. So there's so many factors within the political arena that do not facilitate the inclusion of women. But above all else is the refusal, as it were, because I think Parliament has displayed a complete lack of will to put in place a legal framework to operationalize the two-thirds gender principle. And that in itself has held us back. Now, when you talk about the president, asking Parliament to pass the bill, remember that even the president himself is in violation of this principle with regard to appointive offices. So if where the president has, under his purview, where he does not need a legal framework beyond the Constitution to make the appointments in keeping with the two-thirds gender principle, and he still does not display that political will, we see it also manifested even among his lieutenants, the Parliament, really basically denying the numbers to the bill, because this bill has been tabled. We've been at it since 2011, post-promulgation, and Parliament has actually displayed a complete lack of will by denying the numbers and coming up with arguments as to why they shouldn't pass it and not why it should be passed.
So do you think it is deliberate that it is that way? Why do you think it would be deliberate? Yet it is enshrined in the Constitution. It
precisely. It is precisely that it is. It is prescribed by law, by the Constitution. But I think also in Kenya we have we've inculcated a kind of impunity whereby we have Parliament displaying, or rather behaving as though they are supreme beyond even the Constitution, because the Constitution which gives them those powers is the same Constitution that requires them to put in place a mechanism to operationalize the two-thirds, and they continually resist. If you recall, when Justice Mutivo gave the recent judgment, where Parliament was given 60 days within which to have the requisite legislation, it is the leader of majority on the very same day that actually announced that they will not pass the law, and that the judiciary had no powers to compel them to do so. It wasn't until the president actually made that request that then there was a turnaround. But when you see that kind of attitude, where the Constitution provides very expressly that you can have no more than two-thirds of the same gender, and if you recall, in 2012, the Attorney General actually sought a Supreme Court advisory to avoid a constitutional crisis because there was no operationalization mechanism, which meant that if we go to the polls, any election that gives us more than two-thirds of the same gender would actually result in an unconstitutionally constituted body, and therefore it would be difficult for them to sit. The Supreme Court gave leave for the elections to happen, but gave a very clear timeline within which a mechanism must be in place, and expressly stated that 2017 would have no such cover. So here's 2017 with us. We don't have the mechanism, so we're facing a crisis. And yet, we're still here having this debate as to whether or not, yet the Constitution is very clear.
All right, let me come to Speaker of the Senate, Ekwe Thuro, and your comments. Earlier on, when off-air, you mentioned that you are like a shepherd of the Senate. You make sure that things are in order. Your comments to the fact that possibly this is deliberate, that we still have not realized the two-thirds gender rule.
I must commend Daisy, because she has been around on this particular matter, and she has every reason to put it that way. But I want to discount, because she knows, even before this Parliament, we worked very hard to ensure how this particular provision in the Constitution is implemented. Parliament has a legislative procedure in which we pass bills, and at least one, there have been about 5 bills that have come before Parliament on this particular matter. including the majority leader of the National Assembly, Duale's bill, including Senator Sijen's bill, which I think was the last one in the Senate. We voted on it in February 2017. So the intention has been there to try to implement. I think what you are realizing, I want to agree with that is a bit difficult. We have not been able to come with that law. But in terms of the legislative process through Parliament, we have done it.
Where is the hiccup? Because if it is not deliberate, it is enshrined in the law, and really, why would it not have been passed by now? I remember not too long ago, the president coming out and saying, and marshalling his people and saying, this needs to be done. We also have Raila Odinga, the opposition leader, coming out and marshalling his people and saying, this needs to be done, yet it still did not pass.
I think you have mentioned one. One is to generate sufficient political goodwill through the political party mobilization, as we have seen in many other areas. But I think the hiccup is also we are still in a patriarchal society. And so when you have the majority of the membership being men, it becomes very difficult for them to try to push through that kind of agenda. So those are, it's both what can be done.
One would imagine that's precisely why it is in law, because if it is not in law, then if left to men, it may never actually happen.
Precisely.
Correct. That's why we have it in the law. But you see, the law says this is the state.
way to do it.
Yeah. The state should take legislative and other actions to be able to produce it. Now, in terms of doing that, that's now you have to vote on the bill.
Okay. Let me come to Elisha, who is an advocate of the High Court, and this is a legal matter. It had been given, I think, until August 27th, this year, which it did for it to have passed. But it's something that has been going on. And what is the way forward? It looks like left to men, this may not happen.
You know, let me tell you something about our country. And this is a very dangerous trend in this country. And everybody who is out there must listen. And I'm happy we have the speaker here who must listen. This is a country where people take privileges and people take powers, but people never take responsibilities. You know, it will worry you if you sat with the Speaker of the Senate and he told you we lack sufficient political will to implement this thing. Because you will be sitting there as a journalist wondering, so what would I, in my small way, as a journalist do if the Speaker of the Senate fears also that we lack sufficient political will? You know, if you are a parent and you return home, even at your most broke, you try to put on a brave face so that children don't feel destitute. Because they look at you in a different way. You mean everything to them.
You're the source of hope.
If you exhibit desperation yourself, then there will be a sense of desperation beyond measure among those children. But allow me to point out two things. There is a point of the question of impunity. This country is a victim of extreme impunity that you come across every day as you walk now. It's becoming, it's manifesting itself now more bravely than ever before. So that people can simply say, well, it's there in the Constitution, but we will not comply. Article 3 of the Constitution sets out that any attempt to establish a government otherwise than is set out in this Constitution is null and void, is invalid. Parliament of the Republic of Kenya is an organ of government. It is a part of government. And therefore, any attempt to establish a parliament other than as contemplated in that Constitution is invalid. And we must be afraid as we approach the election that we are playing out bravado saying we will not implement what the court has said, with the consequence that we may establish a parliament otherwise than is contemplated by this Constitution, in the sense that it does not comply with the two-thirds general principle. My reading, call it a two-sense reading, is that we may then have an invalid parliament. That has tremendous consequences on the stability of our constitutional infrastructure and our capacity to function as a constitutional democracy. If I sat where the leader of majority sits, where the Speaker of the Senate sits, where the Speaker of the National Assembly sits, where the official leader of the opposition sits, where the leader of government business in the House, where the president sits, these are not minor positions. These are key positions. They are movers in the political sphere. We will seriously put our minds to putting behind us this small matter. Affirmative action is not a new concept in our democracy. affirmative action is designed to provide a push for those who have been historically disadvantaged. Good students of history will tell you that when we got independence, the black man, the African, was a very disadvantaged person at independence.
Allow me to hold you a little bit there on affirmative action. We'll come to that. But I'd like to get an answer from Speaker of the Senate, Ekwe Thuro, on your comments that somehow, if, as the children, we find daddy is desperate and has no way forward, then where does that leave us? As the Speaker of the Senate.
Michael, I like the expression of daddy. But I think I'm in a very hostile territory here.
Why
I don't think for a single moment I wanted to create the impression that we are desperate. What I was trying to is to give facts and to explain the situation as it is. But it's also not true now because this discussion sometimes make you be defensive when the idea is just to share ideas. It is not true that Parliament is illegally constituted. The advisory opinion sought by the Attorney General in the year 2012 actually said that these rights should be realized progressively. And it gave a deadline of 27 August 2015, which was part of the 5th schedule in terms of implementing a raft of laws as per the Constitution. Now, the same Constitution has provided for 1 year extension on that deadline to August 2016. And so that's why now the crew had to go to court and the court granted their prayers that Parliament, you need to do this. But you see, in a constitutional democracy, even the court cannot tell you, force your hand. This is, this is the way you have to do it. They say, this is the law, you need to do this, like now, within 60 days. So that's the process in which we are in. And there is a whole mechanism, these are legal arguments, and this matter is also in court. There is a whole mechanism. So I don't think, I just wanted to respond to Wakili here. It's not true that we are...
That it's an illegal...
It's an illegal thing, that we are not doing something. We are all in this legal... legalese that we are pursuing.
But what is the fuel that is lacking? Because if it is in the Constitution, you say that people are willing, but you mentioned again that there is lack of goodwill, or rather there is a need for goodwill from the political front. Is that what is lacking for us to have that 2/3 gender principle realized?
You see the way you vote in Parliament, and that's what I'm saying, you actually raised that matter, which I agreed. When a matter requires active participation by the membership, it is usually necessary. And it works better when actually the political party mobilizes its membership. And so that's how you can get the voting taking place. And I think this is what Daisy referred earlier, that, why she sees there is a reluctance is because that mobilization to vote on it is not guaranteed. But on this particular matter, the way I want to take it, to view it, is that, one, this is a fundamental shift in our thinking as a society. That because of the nature of where we have come from as a society, that the legal processes have been put in place. Now, you can take the Daisy's view of wanting it now, or you take maybe the longer view of biting slowly but surely. Like I'm convinced there will be more female members in the next Parliament than this Parliament. Just look at the way, and part of it because of affirmative action. Those 47 seats of women reps, some of them are going to the constituencies. Those women who are nominated to the Senate, some of them are going into the constituencies. So you can see already we are realizing there is progress.
Okay.
Yes.
All right, Daisy.
Okay, first of all, to be fair, I want to commend Speaker Ekwe Thuro because he has truly been one of the people who has been consistent in his support for the gender principle, even when he was a member of Parliament. He was the one of the members that we could count on to stand with us in this argument, and he has also on several occasions used his powers as the Speaker to continue to give life to the Sijeni bill so that it doesn't lapse and encourage members to vote for it. So to be fair, he has truly played his part in as much as he can. But the truth of the matter is this. While we speak about progressive, it is important that we understand that the 2/3 gender principle is in and of itself a progressive mechanism. But it envisions that we start at 1/3. Now, this country behaves as though 1/3 is the end in sight. 1/3 is actually ground zero. That's where we're supposed to start. The whole idea and the architecture around the Constitution is inclusivity and equality. So the 2/3 gender principle envisions a starting point of 1/3. So we cannot talk about progressively achieving 1/3. 1/3 is where we're supposed to start for. Working towards 50-50. That is the ideal, with the 2/3 being a tipping point. So it is a progressive mechanism in and of itself. The problem that we have here is indeed, yes, the patriarchal mindset that is manifesting itself in the lack of political will, whereby members are beginning to see the implementation of the 2/3 gender principle as taking space away from them, so that the inclusion of women is seen as taking space away from the men. And if you look at even the way the campaigns have been happening, the 47 seats, which are affirmative action seats, have been used against the women. Those women who would dare go for the 290 dual gender seats are considered to be very selfish because women have their seats, you know. The mechanism that we have in the county assemblies, which, by the way, is a backup, is actually supposed to be a backup. In the event that we don't elect the required gender, then we top up to ensure that we have gender balance in, or at least the constitutional threshold that is required. But now it is used as a mechanism of bringing in women, so that they say, you don't need to elect them, we will nominate them. So we need a mind shift. And the Constitution, for this Constitution to be given life, we need the kind of leadership that actually tells Kenyans, this is who we aspire to be as Kenyans, and begin to lead the country in that direction. Let me remind the Speaker that the President in 2013, the Jubilee Manifesto was very clear about their intent with regard to the 2/3 gender principle. We have not seen the President pursue implementation of the 2/3 gender principle with the same vigor that he has pursued his other promises, the laptop, the standard gauge railway, you know, the irrigation schemes. He has put his weight behind it. But the gender principle is being left to people to decide whether or not they want to. And that becomes a problem. Because when we have any administration or legislature that picks and chooses what part of the Constitution they will abide by, then we are going down a slippery slope as a country. Because the 2/3 gender principle is a principle of the electoral process. And so those other measures that are contemplated in the Constitution, in addition to a mechanism to implement the 2/3, the other measures are that political parties begin to inculcate in them a culture of inclusivity. So this thing of saying that we can't because, you know, we are patriarchal, the Constitution does not envision Parliament trying. It requires that Parliament shall put in place the legislation to operationalize it. And it doesn't speak of progressive application of the 2/3. It says you can have no more than 2/3 of the same gender in any elective and appointive offices. And Article 81 simply reiterates that the electoral process must ensure that even through the electoral process, you must have a mechanism to ensure that of the elective members, not more than 2/3 are of the same gender. So Parliament cannot absolve itself from that. And while the Supreme Court advisory allowed for the current Parliament to sit, even though it was not properly constituted, it was very clear in its advisory that 2017 will have no such reprieve.
All right.
So we are heading for a crisis.
All right.
Let me just, first I must apologize if I create the impression that I was putting the Speaker under siege. I was not. I talk very straight naturally. Because
indeed, I think we need more straight talk.
I believe in what I say. There's nothing I talk as a matter of just passing time. But having said that, you know, in the 18th century, I think it was the Speaker of the feudal parliament in France once warned the feudal king that sometimes it is good to give in order to keep. So those who wield power, and I address the Speaker very respectfully. The office of Speaker is not minor. It's a state office. It's a powerful office. Let me disclose that. Must ask themselves this question very passionately, very honestly. It was some personal commitment. What can I do using the opportunity that society, that God has given to me, a privileged position, to push this agenda forward? At the end of my tenure, the privilege, the historical position of saying that during my tenure as the Speaker of the Senate, at the heart of a very patriarchal society, I navigated this parliament through achieving this milestone. Number two, the provision of Article 27, sub-Article 8 of the Constitution and Article 81B of the Constitution were put there because we were a patriarchal society. They were put there as a remedy to patriarchy. They cannot themselves be defeated by patriarchy. They were the panacea. So that we can no longer use patriarchy as an argument against Article 27.8. These were the prescribed remedy. Number two, if you look at the prescription of Article 27, sub-Article 8 and Article 81B, the advisory opinion, the judgment of Judge Mumbi Ngugi and the written judgment of Judge Mativo, they don't envisage a situation where Parliament attempts to do. They envisage a situation where Parliament does it. And therefore, the success rate of the Speaker, with all due respect, is whether the institution has discharged, not whether the institution has put in place some measures. In fact, Judge Mumbi Ngugi was very clear in her judgment that the efforts put in Parliament, having read it herself, they were not very committed efforts. That's what comes out of her judgment, as it were. But having said that, I think that as a society, we must answer this question. I'm addressing the question raised by the Speaker, whether or not Parliament is or is likely to be unconstitutional. It is true. The Supreme Court said the implementation date, the date when this mechanism must be in place, is 27th of August 2015. It is true Parliament had a latitude to enhance it by 1 year, which it did. It's also true that Parliament has no latitude to enhance it further. Now, that 1 year ended on 27th of August 2016, when Parliament has no latitude to extend it further. It's also true that the High Court has pronounced itself and given a 6-day latitude, which is still running. And to my calculation, it lapses on 30th, I think, of this month of May. As you sit here in studio, as Daisy sits in a civil society world, as I sit in my classroom in the law firm, as the Speaker sits in chambers, are we seeing sufficient push that this deadline is coming? Let us do something by those who wield the instruments of political power. Remember, at the end of the day, you and me can engage in this debate. But it is the Speaker and those who sit in the hallowed chambers of Parliament who will eventually give it effect. From where you sit, are you seeing that push, that desperation, that anxiety on that team to do something because that timeline is coming?
All right, that's why we're here today, Speaker. That question is directly to you. Do you see that push? And you maybe also to add on to that, you can let us know what might be happening that we may not be aware.
Absolutely. I'm glad you brought me because first I want to say I like the passion in which this matter is being addressed. But we must also come to the reality. And the reality is where I sit, not in his classroom or in his law office or in the advocacy. The reality is now that you have a bill before the Houses of Parliament. There is a process in which that process is
legally carried out.
And I'm saying that's where we have issues. And so we want to see what are these issues and try to sort it. In terms of providing leadership, Daisy, I think, has confirmed in the best wording I could not even put myself, so I don't want to repeat. I think she has given a good defense for me. If she were my lawyer, I would have hired her.
You'd have given her a pay rise.
Yeah, pay rise. But also, more importantly, immediately we go to the court ruling. The Justice Ngugi's ruling was actually in the year 2015. So when she was talking about all those words, you have to factor the time frame involved there. Things have moved on from that time. And so within the parliamentary initiatives have been on. And I think Senator Sijenyi is around to confirm that. Two, we have now, immediately the ruling took place, we sat as two speakers of houses and looked at that judgment and said, what can we do? And we took deliberate efforts in terms of providing leadership. In addition to the other processes that were to ensure that these bills are alive in the houses so that they are not just killed. Actually, in the Senate, it was killed at one time to allow a standing order that we hardly use so that we can continue keeping it alive. To give it one more chance, we exhausted all the chances possible in terms of voting. So that is the reality we are in. Some things, it's not that Parliament has just, or the state has just refused to implement this particular one so that you can actually say it is discriminating against the women. In fact, Daisy is right. A third is the minimum. Our constitutional provision, I have sought interventions, even not interventions, partnership with the parliamentary union where I serve as the vice president in order to help us as a country on some of these things. So we can demonstrate in terms of leadership what we have done. In fact, that team, the international team, confirmed that Kenya's constitutional provisions are some of the best, because we are not working on that minimalist approach. We're actually talking of 2/3, that you can go all the way to 2/3. So that is one. In the Election Laws Act, I think
2016.
They will confirm 2016, the controversial one. But there was something nice about it, that 15% of the political parties' fund will be given to those political parties that are more women representation. So already Parliament has actually done away in terms of the electoral system to promote this particular provisions of the Constitution 81B. And so you have to look at it in terms of many other things that have been done. What we have just failed is this particular one. Okay. And you see, it is not legal. One point. In the same Constitution, in the county assemblies, we made a specific provision on how to fill those positions, 177. But we failed to make the same provisions in the national parliament. And this is why we are having all these challenges.
Okay, so maybe to bring up a point that Elisha raised, and this is the fact that this lies a lot on your desk and those that wield political power. What is the way forward? What is it that can be done? Because evidently deadlines have not been met so far. And just like Elisha mentioned, we have 30th of this month that's coming up, and there doesn't seem to be any momentum building towards that.
That's not true. You are borrowing from Elisha.
I am just restating what he asked so that you can give us an answer.
Heavily. There is a lot we are doing. Right now, there is a bill for publication. I said we met as the speakers and agreed we need one. Let's appeal, because there are issues of law, not because we are against it. Just the issues of law, we wanted also to inform the judiciary. This is something we learned with the former Chief Justice, that you must also put your case to court to improve the understanding. But more importantly, we said even within, before the lapse of the 6 months of the bills, we are going to, fortunately, it is provided for in the standing orders. We as the speakers can allow that bill to be republished. And so, I mean, in terms of desperate measures, we can confirm that we are alive. We may not be looking desperate, but we are alive to the sense of urgency. Now, this is where the other reality sinks in. We have just completed primaries. We will be resuming National Assembly next week. Now, before even the primaries, we had a lot of difficulties in getting quorum. This is now natural attrition. So I don't know what you can really do as a speaker on such natural things.
Let me tell you something. One, is very refreshing to hear the speaker say, we are not as laid back as you think. We didn't come here to accuse. We also came to get feedback. And it's something very refreshing to learn that there's a lot that is happening. There's a lot that somebody is doing to salvage the situation. Why do I say this? Let me just paint this so that you get a bigger picture. You know, this Constitution is a collection of many things. It has promises in it. It promises you, the media, something. It promises me, the worker, something. It promises me, the citizen, something. It promises the speaker as an office holder some privileges, some powers, and so forth. And the sooner we develop a tradition of giving effect to those promises, the better it is for the creation of a constitutional culture. But if we develop a tradition of chipping away on some promises to others, chances are that tradition may have its way. And very soon, it will be the speaker's powers and privileges being chipped away, it will be the media rights being chipped away, and everything to the citizen will go away. And therefore, when I debate this thing passionately, I debate as a concerned and informed citizen of the dangers of allowing any office holder the latitude to chip away any entitlement of any party to this Constitution. It is said an injustice anywhere is a threat to justice everywhere. That's the way I look at it. So it's refreshing when the speaker says, we are doing something about it. I look forward to that coming to fruition. In terms of the appeal, it's perfectly in order. I mean, our law will die if those concerned by the court processes don't give courts an opportunity to pronounce themselves to the highest level on contentious matters of law. But the Speaker raised another important question about the question of the quorum. That's a reality. And I'm also an administrator, and I know the place of realities in management. They exist, you must factor them in, which is what we talk about political will. I can tell this without a doubt, that if there was sufficient political will, this thing can go through virtually all stages of the process in record time. Absolutely. And give people enough time.
And we've seen record time on certain things pass, especially when it comes to...
You remember the other time when the Speaker chaired a session that was called specifically to pass the contentious election law amendment laws. There was political will by those concerned. There was no quorum hitch. It went through. It just means that to the extent that there is political will, that can be done. My urge to the Speaker is this, that he holds an important office. That's something I keep emphasizing, to an office of responsibility. That very few Kenyans, you can imagine that in the whole of this country, 40-something odd plus, million plus Kenyans, only one person is a Speaker of the Senate.
48 now.
That is the Speaker sitting with us. How can that be a less than important office? It's only one person. It's a very privileged office. So the point I'm making is this, that is a position that is a position of influence as well. That over and above discharging the formal responsibility of guiding the House, the influence can be used to mobilize political will, to create, to use what Daisy pointed out, his well-established tradition of will on this subject, to mobilize and ask others of equal or greater influence to mobilize also, so that we can generate the requisite will, so that when Parliament is recalled and people are busy campaigning for their re-election, they'll spare a minute or two for this agenda of national unity.
All right, Daisy, and I see time is also moving very fast, but maybe to just highlight what advantages. Elisha has talked about chipping away of the citizenry's rights, which of course is a very dangerous thing, but we're not talking about tokenism here. We're not talking about just handing over to women simply because they're women. We're talking about creating a level playing ground for everybody to be able to contribute towards national development. Maybe just to hear from you, what is it that we're likely to realize once we achieve this two-thirds gender rule?
You know, I think, first of all, we need to understand that Kenya is made up of men and women.
Precisely.
Half of the brains in this country, half of effort towards nation building, towards economic empowerment, economic development, is actually contributed by the opposite gender. The idea behind the architecture of the Constitution of Kenya 2010 is about inclusivity, so that we all bring our efforts to bear on development of legislation, prioritization of projects, and productivity in this country. We are more than likely to see more socio-economic issues addressed, because one of the things that we always say is the wearer of the shoe knows where it pinches. We have certain issues that are considered women's issues, you know, women's issue, but they have a wider impact on the whole community. Look at issues like healthcare. You know, when we have a breakdown in basic healthcare services, women become the primary healthcare givers, okay? It takes them away from doing other productive work. One of the things that we have seen is that with more women, you have more socio-economic issues addressed, issues of healthcare, water, sanitation, you know, that contribute to the wider productivity and well-being of the family, the community, and the country at large. We have seen, even just by the women that we have right now, because I think the 11th Parliament has the highest number of women ever in independent Kenya. Look, food security bill, which was tabled in the Senate, was brought by one of the nominated women members of Parliament, Beatrice Elachi. This is a perennial issue that we continue to grapple with as a country, the issue of food security. But it is not until we have women in the House that those issues become priorities. When you look at the National Assembly, the protection against domestic violence, where women are safe in the home, where families are safeguarded in the home, the state putting in place the necessary measures to ensure the safety of those women, the matrimonial property laws, where the property, marital properties, are safeguarded from some of those patriarchal instincts that we see being manifested by men, but it goes on to secure the family. We have seen several issues, social services being enhanced. We've seen an expansion of the safety net, more vulnerable people being taken care of by the state. So we begin to see more humanity being inculcated into state agency and the services that are delivered by the state. Now we can only see more of this. And it enhances the productivity, because even when you look at the statistics of the families that have been benefiting, the vulnerable, the orphans, and the poor people who've been benefiting from the social safety net, you find that many of them have gone on to become more financially independent and more productive as citizens. So I think that we cannot deny that having a more balanced approach to development, bringing both men and women to the leadership and decision-making table, gives us more opportunities to develop ourselves further and to enhance the productivity.
All right, can only be a good thing. So, Speaker, Mr. Speaker, sir, we have a deadline coming up, and what is it that we can hold you to account to come 1st of June, and you'll tell us, I did A, B, C, D to ensure that this is realized within the power that you have? Elisha has talked about responsibility.
The approval of the bill, republication of the bill. That's the only thing I can. But let me agree with the Daisy in terms of the importance of these provisions. And this is why they're in the Constitution, and this is why we are grappling to ensure that this bill is passed. Because it's not even 50-50. Women actually, the last time I checked statistics, 52% of our population, they're even more than the men. And they bring certain qualities and contributions to leadership. And this is extremely important. We have seen it. But you cannot deny, overnight, the effects. I like this high expression again, patriarchal effects of this society. This is taking us back. But I don't think in terms of the argument about this particular piece of legislation that is being proposed, that we are chipping away. There's nothing we are taking away. We're actually trying to bring those benefits to that particular segment of our society. And these are real concrete proposals that are being deliberated. And I'm just saying it is such a fundamental shift in our thinking, in our history, in our country, that it is taking a bit of a while to implement it. And she knows it. We have been, for me...
Well, it is meant to be progressive.
For me coming from...
is it not meant to be progressive?
No, the legality is that it's not meant to be progressive, but in terms of reality. Already now, we busted the 5 years, 2013 elections,
but only because
2017.
Only because there has been the lack of political will. Good. And for me, the Speaker is a very influential man. Aside from the fact that he holds a very influential position, the Speaker can speak to certain holders of power to make them understand, even educate them and encourage them. And encourage them, And that is what we want to see. Because he has relationships that he can actually build on to actually help steer this debate to its logical conclusion.
All right, closing comments, Mr. Speaker.
Yes, we have made progress. Parliament has done its bit. This is a societal issue. We all need our bit. An opportunity is now before us in terms of the general election. So I want to speak to the Kenyan electorate. This is the opportunity because part of the challenge we are having that this is an elective thing. Even within Parliament, you must vote on it. Even in terms of the gender composition, it is up to the electorate to ensure that there are more women coming to Parliament. And I think for now, we have a real opportunity. When 2013, not a single woman was elected governor, not a single woman was elected senator, until we had to invoke the provisions of the Constitution in terms of nomination. But I think now women have come out there, ready to serve in leadership positions. I want to appeal to the Kenyan electorate, and I'm very confident that some of these women will come to Parliament. In the Senate, we only need 2, and will be very compliant. So that's why I'm not worried. Thank you.
All right, Elisha, your closing comments, and also, should this not be realized within the Constitution, can Kenya go to the Africa Court?
There are many legal options available. As lawyers, we have, happily for me, I have litigated all those matters that you hear us mentioning here. I've taken them to court myself. And then that's why when the speaker says they're going on appeal, I say bring it on, because it's not a matter that I engage with culture. But having said that, allow me to remind everybody who listens, the speaker has been good advice, that the electorate, the battle is partly in your hands. But let me remind the speaker that the essence of affirmative action is because that free market is deemed inadequate as a forum to deliver. That's why we insist on affirmative action first, to deal with a historical mindset issue first, before we resubmit this disadvantaged population to the marketplace. But again, finally, and very importantly for me, you asked the speaker, what do we expect on 30th of June, or 1st of June, and you said June, publication of the bill is what you can promise. That is not what the Constitution envisages. The Constitution envisages a legislative measure to ensure that not more than 2/3 of the members of elective and appointed public bodies have the same gender. A legislative measure. The legislative machinery must reach its fruition to give us that machinery. Anything else is what the white man used to say, a half work done is no work done.
Is no work done. Thank you very much. We'll have to wind up right there because of time. Daisy Amdani, who's the coordinator for National Women's Steering Committee, Elisha Ngoya, who's an advocate of the High Court, and last but not least, Speaker of the Senate, Ekwe Thuro. Thank you very much for joining us on the State of the Nation this morning. And you who are watching, thank you also for joining us this